Alex here with part 45 of the My Docket series on child custody and visitation. I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will quickly glaze over are, number one, I am not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. And that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. I also like to take a moment every 5th video to remind my viewers that if you have not clicked on the bell notifications button and you are just a subscriber, YouTube will not notify you about every single video from the My Docket series that I publish. You'll probably just get notified of some of them, and I don't know how it works, but I guess YouTube's algorithm picks and chooses which things to send you an email about. But if you click on the bell notification button, then YouTube will notify you of every single video that's deployed to the My Docket series, and that way you won't miss one. We left off in part 44 with the government's response to my petition for judicial review, and I guess more on point is where we left off in part 43, which is when my ex filed an opposition to the motion that I filed in part 41. The motion that I filed was a request from me to the court to get some kind of procedure put into place, specifically into a court order that would have a binding effect on my ex's ability to set future non-emergency appointments. And we're talking medical, dental, vision, and educational appointments. I got the opposition, which I already went over in part 43, and my ex's argument was, for the most part, that because I was not an involved parent in the first place, I had no right to be an involved parent now. Not that the premise was true, but basically she argued that since I wasn't involved all throughout his life, then the court should not allow me to be involved at any point going forward into the future. This is a fallacious way of thinking with respect to how the best interest factors work, and I think the best video that I have on this topic is Deserve Custody or Deserving Custody. I can't remember how I titled it now, but it's one of those two. And I'm not going to talk about it a whole lot in this video because I've already dedicated an entire separate video to that topic, but I would like to go into my mindset, I suppose, before I go into what is in my reply. And I do remember at this time being really frustrated, and that's mainly because the government's response in the petition for judicial review action that I filed, I guess it's specifically called the judicial review action, it wasn't what I expected. I was really naive at that point. I didn't understand anything about jurisdiction, about statutes, rules, and case law. I just kind of slapped together that petition and I put, the most important points into it, which are relevant, but it's not even the correct petition to file. So I talked about this a lot in parts 44 and 42, that I shouldn't have even filed a petition for judicial review. So I wasn't too gung-ho at this point. I was also frustrated with the fact that my ex was trying to restrict my ability to continue to be involved in our child's life, and especially given the fact that she characterized me as an absent parent or a disinterested parent, which it just could not have been further from the truth. But as I have explained in the video, they will never say good things. When you're dealing with an ex and an attorney who has a specific objective in mind, if that objective involves litigating, they're not going to say good things about you, because if they do, that kind of undercuts their own position. They're forced to come up with some kind of plausible explanation as to why they think they're entitled to what they're asking for. And in this case, the best thing she had was the lie that I wasn't an involved parent. I think at this point we can just go ahead and get into what I have filed. Here we have my reply to opposition to set procedure for non-emergency appointments. Scrolling down, in the first paragraph, I identify myself to the court. I indicate that I am representing myself and that I am filing a reply to opposition. Okay, I wouldn't recommend it doing it this way. What I like to do, and I figured this out sort of around 2008, 2009, is to start filing oppositions and replies specifically mentioning the document that I'm opposing or replying to by title, and more importantly, helping the court identify it by putting down the date that it was filed. So this isn't going to backfire on me, and probably wouldn't really get in anyone's way, to be honest, but it is a great habit to get into because it tells the court specifically by date and title document that you're responding to, which makes their job a little bit easier and less confusing. It doesn't mean they can't review the docket and use logic to sort of figure out what it is that you're replying or opposing, but it's a good habit to get into, and a lot of attorneys, I think maybe even most attorneys, do that exact thing. First paragraph. Okay, first thing I want to mention is the layout. I don't recommend doing this. I can understand why I probably did it this way, and that's because I am 99% sure self-help forums in Nevada actually take this approach. This line-by-line, paragraph-by-paragraph approach. It's fine when you're doing one of those self-help forms, but if you're going to prevent a custom document, you may as well put it together. You may as well put a presentation together in a way that flows better, that's easier to read, rather than just going line by line based on your ex's document. I don't think I have ever seen an attorney file an opposition or reply like this, where they go paragraph by paragraph. And if they have done it, it's so rare that I can't even remember. And I know that this is appropriate when you're doing like when you're filing like an answer or a reply to counterclaim. Those are pleadings. And I think the reason why is because they're just so straightforward. You don't really elaborate on anything. You just say paragraph 1 admitted, paragraph 2 denied, paragraph 3 admitted, paragraph 4 denied, and so on until you're all the way, through all the paragraphs, and that's it. It's a very simple filing. An opposition and a reply is supposed to brief the court. It's supposed to go in depth into the issues, and so I think for that reason, this approach is not an approach used by any attorneys that I can think of. And so just letting my viewers know, even though I did this, I don't recommend doing it. If you're going to prepare your own custom papers, you may as well go all out and make it flow better and make it more easier, to understand sort of where you're coming from rather than breaking it down little by little like this. So first paragraph, I am indicating to the court that my approach is approved, I guess, what I'm trying to say. The courts encourage the use of motions to clarify conflicts of ambiguity. That could be worded better, and the way that I recall the Supreme Court articulating this sort of principle is, and this is from Rivero 2009, they basically say that when parents cannot agree on a legal custody issue, they are supposed to return to the court on equal footing. Now, most judges, family judges, don't like that idea. Family judges think if parents don't agree, they just need to try to agree even harder. It's like, keep on trying. And if you can't agree, then just one of you just give up and walk away. That seems to me what the family judges expect from parents, but the Supreme Court has your back on this. If you can't agree, they say that the approach is supposed to be to return to the court on equal footing. I did not cite this, and I should have cited it. It doesn't backfire on me, but it could have. And as always, just because something works out for me doesn't mean I'm not going to bring it up as a potential problem that may arise in your situation. Paragraph 2. I disagree again. This goes into my ex's failure to communicate in good faith. And I think this is a way that most or maybe even all high conflict exes or emotionally immature people communicate. They don't see communication as a sort of constructive approach to solving a problem. They see it as a sort of way to assign blame. It's like they're fending off accusations, and they need to figure out how to make sure that it doesn't fall on them. It's a more like adversarial way of looking at communication. It's, I talk about it in my video, communication. I highly recommend watching it. But one of the things that I think I mentioned is that where a normal person might use communication to sort of clarify something that's confusing, they use it to sort of obfuscate it or make it even more confusing. And they have this weird way of agreeing without appearing to do so. I don't know how to describe it. You just have to sort of read one of their responses to really sort of see the weirdness in their approach. Anyway, I'm not going to talk any more about it because I have a video dedicated to the topic, and that is communication. Scrolling down. Here, I am disagreeing again. I am mentioning that she's making some token offers to attend appointments with her, and that those... Okay, so what do I mean by token? It's like she's saying that I can approach, one of these appointments, but she really doesn't want me to. And the way she shows that is not in her words, but in her actions. So she'll send like an email saying, hey, you can come to this one. But in her actions, when she's at the appointment, she's obnoxious. She uses sarcasm. She accuses me of things in front of staff, innuendo. And there have been some occasions where there was just full-blown arguments. And it's like, I wouldn't engage in it, but I felt like she was trying to get me to engage in it. And again, I think this goes to her idea that she just needed some witnesses. And so to get me to react, she would have to be ridiculous. And all it did was make her look bad. And even worse than that, it made her son look bad. And it kind of made me ashamed for him because it's like, wow, all these people are going to think this poor kid has these messed up parents. I could not stand the fact that she would do that at these appointments. But it is one of the things that she would do, and she didn't seem to lose any sleep over it. It was basically all my fault since, number one, I shouldn't have been there if I didn't want to go through it, and number two, I shouldn't have dared to defy her. That's the sort of idea that I talk about when I go over the revenge cycle. If you want to learn more about that, watch my video, Failing to Agree. No, that's not it. Watch my video, Fighting Makes It Worse. That's the video. But they basically get this sort of, how dare you defy me attitude when they don't get their way, and so they react by getting worse. And it's funny because if they do get their way, they still sort of react by getting worse, but it's just like a different way. Instead of anger, it's more like a sadistic desire to punish you, to make sure that you stay in this little trained puppy dog state. So if they get what they want, then they want to punish you like this cruel master. And if they don't get what they want, then it's like, how dare you? I'm going to get revenge, and I'm not going to stop until you give up or you quit. It's the sort of underlying bedrock principle behind everything that they do is that everyone else is making them do it. It's like, I'm doing crazy stuff, but you all made me do it because you're getting in my way, or you're not letting me get what I want. And so it's all your fault, because if you would just get out of my way or let me do what I want, then I wouldn't do any of this stuff. All of this is kind of covered in those two different videos, communication, and also in the other video, which is Fighting Makes It Worse. Next paragraph here, disagreeing again. My ex says that all terms refuse to negotiate and cooperate. She's been concealing appointments, which is true. She's not even telling me about them. This is not something that's going to be solved right away. This is going to continue even after the court enters an order on this. But what she's been doing, I describe here in this paragraph, which is to basically frustrate my ability to go to these appointments. Paragraph 5, notice how any attempts at cooperating with her are immediately referred to as harassment. Okay, this is one of her go-to statements. Stop harassing me. It's like her favorite 3 words throughout the case. And she's just going to continue to say that over and over again until it blows up in her face, which it does eventually blow up in her face. And I think it happens in 2014. So rather than talk about it, you'll all get to see it at a hearing, because the judge actually goes over the way she uses that phrase, that stop harassing me. I think that she was using that because, and this is not just this one thing, but she seemed to be doing this with pretty much every communication that she sent to me. She had this idea that if she stated it in an email, then it was true, even though it actually wasn't. It's like, by discussing it with me, magically it became true. And I don't know for sure if that's 100% what she was thinking, because there's another small part of me that thinks that she knew it was a lie. Well, She already knew it was a lie, even with my first example. There's another piece of me that thinks that she wanted me to argue with her about the lie. Like, she wanted to say something that wasn't true on purpose so that I could, argue with her about it and bicker with her about it so that she can in turn reply to me. And then we could have this back and forth endless email string about this one thing that was never true, that she knew wasn't true, but the whole point behind saying it was just to get me to go back and forth with her, into 30 or 40 or 50 different emails. So it's one of those two things. It's either she's trying to create it into evidence, or she's trying to get me to go bananas. It's one of those two. And again, I talk about that in the video communication, because that's not something that really kind of falls into its own category. It goes back into the communication problem. I'm disagreeing with her again. She's claiming that she's afraid of me and that she requires safety, and yet she contradicts herself by insisting on appearing with me during his appointments. And that's kind of something I'm taking advantage of here. I know she's not scared of me, because none of the stuff that she said I, did with regards to DV is true in the first place. So I'm basically at this point saying, fine, if you're going to say you're afraid of me, then you should be embracing this idea that we both go to appointments separately. You shouldn't want to be anywhere near me. But it's just this contradictory, she's just a walking contradiction just all over the place. Because, going back to one of the earlier things she said, is that she was afraid of me at these third-party exchanges, and yet she would try to provoke me at the exchanges. And then you have the other problem of, there was another problem, where she's trying to allege that, I've committed all this harm on her, when really the only proof that's out there with regards to anyone who's committed harm on her is herself. She's harmed herself to the point of having to go to a mental health institute on it. So I'm not going to elaborate on any of those 2 points, because they both go into things that will yellow flag my video. And if you want to learn more about what I'm talking about, you can definitely take a look at part 8 and 9 of the My Docket series with regards to the DV stuff. And I think there's some good stuff in part 30 and part 32 with regards to all of the other allegations that I addressed, specifically the conflict at exchanges. And part 7, or paragraph 7 here, she's attempting to make it appear as though the sole basis for the procedure is her mental instability. But I really want the court to be aware of all the facts, including her mental state. So that's not the only thing that I am discussing. I think this is where she is attacking my use of her mental health incident. And the only thing I can say to that, and I should have cited this in this reply, which I didn't do, but again, I don't know the value or the purpose of statutes, rules, and case law at this point. We're still in 2009. But what I think that I should have done is cited the best interest factor, the mental health of the parents, because that factor basically makes my assertion relevant. I'm bringing up the mental health issue because it's relevant under the best interest factors. And I do eventually figure this out, and you'll see me start to cite that statute, but at this point, I haven't figured that out yet. Here is where I counterattack my ex's request for attorney fees. And let's see, I'm dismantling it pretty well here. Oh, wait. Well, I didn't cite 2B. Close enough, though. 18.010. I should have mentioned subsection 2B, but I didn't mention it. But here, where I have in quotation marks, when the court finds that the claim, counterclaim, cross-claim, etc., that is actually the on-point statute. That specific paragraph that I'm citing is absolutely relevant at this time. Later on, the legislature changes the law, and that happens in 2015, but that hasn't happened yet, so I won't discuss it. Back here in 2009, this defense is the best defense, because it tells the court that under the statute, my ex cannot recover attorney fees unless she shows 2 things. Number 1, she has to win. But that's not enough in and of itself. Not only does she have to win, but she also has to show that I brought a claim without reasonable grounds or with the intent to harass her. And both of those are a requirement. So this is a much better way to oppose my ex's request for attorney fees. I discuss this precise approach in the video, Defend Against Attorney Fees. I highly recommend the video. If anyone is in Nevada, because of 2015, unfortunately, you're going to also have to take a look at the video, Attorney Fee Equalizers. That makes things much worse for you. Unfortunately, the legislature, I think, went in the wrong direction with this statute that they created. But you're going to have to be aware of it being in Nevada, because it does help the judges to award attorney fees in these types of cases. And this was very difficult for them to do prior, but now this is something that it's easier for them to do. So my defense here is in line with what I talk about in the video, Defend Against Attorney Fees, and I recommend all of my viewers use this approach rather than just try to grapple with their ex's general overarching principles of fairness and morality with regards to attorney fees, because when it comes down to that, there's really two ways to look at it, and one of the ways does look at awarding fees. That's why you want to use the law, because the law is very favorable to you in this situation. According to, actually, let's just move on to paragraph 9. I disagree. My ex contends that all I need is the doctor's names and addresses. Wanting to set a procedure is out of the question for her. Here I find it fitting to use her own exhibit as an example against her, where she's trying to convey plainly, or where I am trying to convey plainly, simply, and without disrespect to her wishes, and she replies with an interesting perspective that the court ordered me to first speak with an attorney before filing motions, which isn't true. Okay, so she's trying to bring up this notion that I have to discuss something with the attorney before I file a document. This isn't true, and there is some local rules that require you to discuss an issue, but it doesn't necessarily require you to discuss an issue with the attorney. What they want is for you to try to work it out with your ex prior to going to court. There's nothing in there that specifically says that you have to send a communication to your ex's attorney. It's just that you need to try to resolve the issue. The thing that they're trying to avoid is just filing papers just without even trying to work anything out, because that is consistent with what a harasser would do. They wouldn't try to work anything out. They just want to go to court just to drive you nuts and bring up your attorney fees. So first thing I want to mention is that local rule doesn't even apply to me anyway. That's a rule that applies in 8th Judicial District Court of Clark County, and other states may have this rule as well. So make sure you look into it. But I talk about that rule in a video, Requirement to Attempt Resolution. And in that video, I'll explain the details as to how it works. But none of this applies to me because there's no local rule in Washoe County that matches what I'm talking about with regards to what's in Clark County anyway. So even though it doesn't apply to me, I would like to mention as an aside that it is a good habit to get into. You do want to at least try to work something out before you file a document. Whether or not a rule or statute requires you to do so doesn't matter. It's just the right thing to do, is to at least give your ex a chance to work it out before you just go straight to court. She maintains the arguments and requests that she has outlined in her original motion. I maintain my arguments and requests, that I've outlined in my original motion. And I'm asking the court to once again deny my ex's request for attorney fees. Here's my affidavit, which is required under the court rules. This is what binds you to the facts that you have alleged in the paperwork. And what I mean by binding is you are now swearing under penalty of perjury that everything that you've alleged, everything factual that you've alleged, is true. Affirmation, which is just indicating to the clerk of the court that there are no social security numbers in this document. List of exhibits. Okay, so exhibit 1 is the opposition to motion, so I'm not going to go over that, but I will take a look at exhibit 2. And the reason why I don't go over something that I've already gone over is because I've already gone over it. And if you want to look at the opposition to motion and my analysis on it, you can just watch part 43 of the My Docket series. So let's go ahead and skip to exhibit 2. What did I write on here? Oh, these are just my notes. Here's my exhibit 2. Okay, so this is from her to me. She's trying to quote back to me what I just said. If there is a single put down, single accusation, or single incitation of argument, I'll tell you right now my reply before even reading your response. Basically, if you don't... Oh, so she cut off the rest of it. So basically, if I don't agree with everything you ever say or try to tell me to do, then I can take it to the court. This isn't communication, this is dictation. You can take that to court. I have no desire to talk about this. That's why I have a lawyer, so you can't stress me out or harass me. Like I said before, stop emailing unless it's something directly to do with her son's immediate health or needs. So it sounds like what she's arguing is anything that's non-emergency doesn't count as an immediate health need. So anything that's non-emergency, she wants me to talk to her attorney about. This is ridiculous. The courts expect you to work out setting appointments for your kid's mental health, vision, etc. They don't expect you to communicate that stuff through an attorney. They do expect you to communicate legal issues through an attorney, but they don't expect you to communicate things with regards to the upbringing of your children to the attorneys. Some people have to do that because it's just that bad of a situation, but that's certainly not what's expected. And this is kind of funny because she sort of spins this in a very negative way, but this is actually what you're supposed to do. She sort of says that if she doesn't agree with me, then I can take it to court. But she's saying it like it's a bad thing, but that's actually exactly how it's supposed to work. And she's saying that that's sort of dictation, like I'm trying to control her, and that's exactly what I'm trying to do. That's what court is. Court is control. This isn't a place that you go to sort of be diplomatic. You can do that before going to court. Going to court is confrontational by its that's how it works. And when a court enters an order, that court is imposing its order on the parties. This is by definition the use of force. So she's trying to portray this in a way that is like evil or negative, but that's the point of the whole system. You try to agree, and if you can't agree, then you go to court, and the use of force is implemented. Legal force, but it is still force under threat of contempt. So it's like she's trying to put together this version of reality that's just not true and not consistent with what even the court itself understands. So none of this was really brought up. None of this really mattered to me. This is like, for the first time I'm reading this, and it's just a recollection that I'm having right now. But yeah, to my viewers, and this thing about stop emailing unless it's something directly to do with your child's immediate health, that's another legal custody problem. This parent shouldn't have legal custody. Because you're not supposed to just communicate about immediate health needs. You're supposed to communicate about all health needs. So I'm going to continue to move on here. She views it as harassment. Again, this is just something that she continues to say throughout the years. If I want to change something about the case, you should be directing it to the lawyer. She will contact with the details. I will not speak about any changes. This isn't true because she just goes back and forth. First she'll say, go talk to the lawyer. Then it backfires on her in court. Then she changes and she'll start to talk to me again. It's weird because it's not consistent. Sometimes when she doesn't like what she's being told, she's like, she'll say, I should have sent it to the lawyer. Other times when she does like what she's being told, she's happy to go along with it. So none of it's going to really flow. It's just going to be, it's like dealing with a big ball of chaos. So this is for the most part, they're just the same stuff, just an extension of the argument. She gives the address and name of a doctor, which is good. And I can't tell what this is. This might just be a thread. Nothing is jumping out at me. As with all my previous videos, guys, take a look at... Oh, look, here's... Okay, I'll finish what I was going to say. As with my previous videos, you can go down in the description below and click on the links to download these documents. And if you have more questions based on something that I skipped over, just mention it down in the comments and I'll respond to you. But one thing before moving on is here's the part where the whole right of refusal thing is being brought up, and I'm actually addressing it. And I'm indicating here that it doesn't formally exist. There's no precedent that it's ever been established. And basically, that's just me saying there is no right of refusal in this case. So this is the first time that I really confront this, because I don't think I've come over, like an email that covers this topic yet. But this will continue to come up for sure. Okay, moving on to the request for submission. And since my reply has been submitted to the court is now fully briefed. So the court is going to need to consider the motion, the opposition, and the reply, and make a decision. I have a video dedicated to request for submission. Please take a look at it, because some people may be in a jurisdiction where it's required. As I mentioned many times in the past, there are jurisdictions, many of them, that do not require you to file a request for submission. Second Judicial District Court does, and the reason why is because the court does not review any of the filings until you tell the court that it's time to look them over. And the way that you can tell the court that it's time to look them over is by filing a request for submission. Okay, affidavit of service, and I'm indicating to the court that I served the reply and the request for submission on my ex's attorney. I'm not indicating how I served it. Oh, personally, it's in bold. Okay, so I'm just indicating that I physically took the documents to my ex's attorney's law office and dropped them off. And I'm affirming that this document also does not contain a social security number. Here we have the notice of respondent's mailing address and fictitious address. So this is probably my ex just notifying me of her address. I'm not sure why. Huh. Okay. Well, she's just letting me know her fictitious. I think I've already signed an acknowledgement of this anyway and already submitted it. So it's like an extra document that the court is, or that my ex's attorney is filing for some reason. Okay. Oh, I see what she's doing. She's asking for me to mail everything to her mailing address rather than to her fictitious address. Okay. One of the things, I'm going to mention this now. My ex alleged that any mail that went to her fictitious address was delayed by several days. It really makes me wonder if that's true, because that would kind of frustrate the whole point of the fictitious address program. And I don't even think she said it was a couple of days. She said it was like weeks or something like that. It's very unbelievable to me that the government would do that, because some people might get important mail that needs to get to them very quickly. So I highly doubt this is true. But anyway, to avoid this sort of back and forth, my ex's attorney just says, please mail stuff to her P.O. box. Don't send stuff to her fictitious address anymore. And there's an affirmation here. It's a self-help form document that she just filled out. Or, well, this isn't even her handwriting. I'm sure this is her paralegal. And certificate of service indicating that it was mailed to me, which she can do under Rule 5. Going into the aftermath, I have filed a reply and a request for submission and an affidavit of service. All three of those are free filings, so I incurred $0 in costs. My ex's attorney filed a notice, another free filing, $0 in costs for her. I don't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably put 10 minutes. I'm stretching it at reviewing my reply. I don't think I cited a single law. I'm just really using plain English to respond to her opposition. And the request for submission, affidavit of service, I'm just going to make those 5 minutes combined. Total of 15 minutes. The notice of her address, I doubt she put even a moment, even a minute into that. That's just something that says, hey, here's the address I want stuff mailed to. So I'm going to just count that as 0. So we're looking at 15 minutes. And my ex's attorney's fees at $250 an hour. That's going to come to $62.50 in attorney fees. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.